once said, there can be no keener revelation of a society's soul than the way it treats its children. The people who sexually exploit and abuse children must be held accountable, not only to society, but to their victims. Incarceration and sex offender registration are ways to hold these criminals accountable and responsible for their despicable acts. Child pornography, or child sexual abuse material, or CSAM, is a horrific crime that plagues victims long after the initial sexual abuse. My name is Alessandra Parisi Serrano. I work for Operation Underground Railroad, a nonprofit organization that partners with governments here and around the world to help victims of human trafficking and child exploitation get the necessary aftercare and support they so desperately need. Operation Underground Railroad also helps train foreign law enforcement and other entities who may have contact with potential victims on how to identify, investigate, and prosecute traffickers and exploiters of children. I recently joined this organization in December of 2021. For the preceding 18 plus years, I served as a federal prosecutor for the U.S. Department of Justice. During my DOJ career, I personally handled hundreds of child exploitation and human trafficking cases involving thousands of victims. I saw firsthand not only what these victims endured from the initial abuse, but also the continued abuse and exploitation for years to come, oftentimes for the remainder of their lives. The Supreme Court in the Paroline case recognized this fact when it allowed victims depicted in CSAM material to obtain mandatory restitution from voyeurs, distributors, and transporters of CSAM long after the initial sexual abuse has occurred. While the initial sexual abuse causes great harm from which victims may never overcome, CSAM re-traumatizes victims for years after their abuse. Every time a person views CSAM, that child is re-exploited, re-traumatized, and re-abused. When an offender is caught viewing, downloading, or distributing these horrific images, mandatory notice goes to these victims that yet another offender viewed CSAM. Upon receiving these notices, victims are forced to relive the crime. Persons who download, view, and distribute CSAM cause an increase in the production of CSAM images. No one wants to see reruns of TV or movies. We've all experienced this during COVID when the release of new movies and TV shows stopped. And that includes voyeurs and distributors of CSAM. With this appetite for new material comes the increased demand for the abuse of younger kids in more violent, sadistic, and masochistic images, according to recent statistics. I personally prosecuted cases with images of abuse and exploitation of children as young as premature infants. This trend by certain judges to routinely decrease sentences far below the advisory sentencing guidelines and prosecutors' recommendations for CSAM consumers minimizes the gravity of the offense. While the amount of material being produced and number of people consuming this material has increased exponentially over recent years, the sentences have decreased. This makes no sense. I live in Southern California, where destructive wildfires are a yearly issue. The fires leave hundreds of victims in its wake. When the fires spread and get bigger, do we put fewer firefighters on the front line, use less water or resources, fewer containment measures? No, of course not. That scenario is akin to routinely reducing sentences for CSAM consumers when the supply is undisputedly increasing. I say again, it makes no sense. I hope all of the members of this committee agree that there is no cause more noble than protecting our children. Whether some crimes warrant longer prison sentences is a debate left for another day. However, purveyors of CSAM, especially those with prior conduct involving sexual abuse or exploitation, deserve to be taken out of society for a substantial period of time and to be identified by the public through sex offender registries. It has been my experience that offenders are only remorseful because they get caught and not because of what their deviant and destructive conduct has done to countless victims, many of whom are unidentified. Lastly, the notion that CSAM crimes only involves pictures is appalling to most prosecutors and victim advocates. CSAM depicts real children who deserve justice. These victims or survivors deserve our respect and dignity for what they endured. They do not deserve to be treated with less consideration than offenders who take sexual pleasure in viewing CSAM of what is the darkest days of their lives. Our society is better than that. At least I hope it is. Our most precious resource, our children, deserve it. On behalf of victims of CSAM and other sexual exploitation, I thank you for the committee's time and attention to this important matter. Thank you.
Thank you, Ms. Serrano. We're now going to have rounds of questions. There are 5 minutes. 5 minutes. I hope the members will hold to that standard. I'll begin. And let me start with Captain Thomas. Thanks. Thanks for coming here. Thanks for more than 30 years of service in law enforcement. Thanks for more than 26 years of military service, including combat duty. It's an honor to have you as a panelist here, as it is with all of our panelists, but certainly I wanted to commend you for those things.
Thank you, sir.
You're probably aware of the fact that Judge Jackson has received the unqualified endorsement not only of your organization, Noble, but also of the Fraternal Order of Police and the International Association of Chiefs of Police, in addition to other law enforcement officials. Are you aware of that?
Yes, sir.
So there have been charges made yesterday, day before, even this morning, that she is somehow part of a, quote, anti-incarceration, anti-police movement, that somehow she is affiliated with a defund the police movement. Would you or your organization have endorsed her if that were true?
Sir, that would never happen if we knew that she would have made a statement like that. We never saw that in our research. That never came out. And I don't really think it's true, sir.
I don't either. And I would assume the same thing is the case for the Fraternal Order of Police, the largest organization representing rank and file policemen in America, and the International Association of Chiefs of Police, respected at their own level for the leadership they bring to law enforcement. So that is a charge which I think is belied by the fact that this endorsement has taken place.
Yes, sir.
Wade Henderson, you were in the audience. Welcome back. You were in the audience and heard the earlier testimony from the American Bar Association. 2 or 3, maybe 4 members have really dwelled on this whole question of sentencing in child pornography cases and child abuse cases. And I asked the 3 representatives of the American Bar Association if they had made inquiry among the professionals, prosecutors, defense lawyers, judges who have witnessed Judge Jackson's role in criminal justice, particularly in this particular area of the law. And they testified that they had consulted with 250 professionals to reach their conclusion of giving her a unanimously well-qualified rating. And I asked them during the course of this, since we spent so much time here with 3 or 4 members dwelling on that issue, whether they found any evidence to back up the charges that were being leveled at this committee level, and their answer was no. No evidence, not at all. You would think that one person out of 250 would have found the same conclusions as 3 or 4 of my colleagues did in the last several days. What is your conclusion from that?
Mr. Chairman, your questions to the American Bar Association representatives, in my view, were dispositive of this issue of whether Judge Jackson in some way was outside of the legal mainstream of other jurists or somehow tolerated the abuse of children implicitly by the questions that were posed. I thought their responses this morning were completely dispositive. I began when I saw the testimony yesterday thinking that, unfortunately, this hearing has devolved in some ways to a partisan attack on an otherwise extraordinarily well-qualified nominee. By any standard, Judge Jackson's record, both on and off the bench, her academic achievements are unparalleled with almost anyone who has been appointed to the Supreme Court. A failure to find her vulnerable on the basis of qualification has somehow led to a series of questions focused on 7 decisions that she rendered in sentencing that, in my view, bordered on the demagogic. I think when one takes a look at the repeated effort to pose questions about her record somehow being outside of the mainstream, indeed reinforced that view. Ultimately, I think the issue, as Senator Whitehouse mentioned, was both asked and answered. and that the judge had clearly demonstrated that she was well within the mainstream of judicial thinking. Finally, I felt that the criticism of some directed at her for her decision-making was misplaced, to the extent that her decisions, at least to those who questioned her, were somehow at variance with what the law was. They could have said that. No one did. But they could also recognize that it is up to Congress to establish the standards that judges apply in their decision-making responsibility. To the extent that there were questions posed about her, better to look inward at the role that Congress played in establishing the role that judges fulfilled in this moment.
Thank you, Mr. Henderson. Senator Grassley.
Ms. Mascott, we heard several times from Judge Jackson that her judicial philosophy is in her 500 cases or whatever number that we have from her district court work. So that was her answer to the questions about what's your judicial philosophy. How important is a justice's judicial philosophy in determining how they will rule on the bench?
Sure, Senator. Well, I think as these hearings and numerous Supreme Court nomination proceedings previously have indicated, is judicial philosophy is obviously paramount because in contrast to the political branches, this body and the presidency, judges have a limited role to decide cases and controversies. And as Mr. Henderson is saying, Congress has a large role in establishing what the role and the jurisdiction of courts are going to be and the procedures they're going to put into place. And so a judge's approach and philosophy in interpreting both the Constitution and statutory text is critical. And in the past, I think nominees that have gone on to serve on the Supreme Court and be committed and consistent and exclusive in their adoption of originalism and textualism have clearly discussed those methodologies, those philosophies, expressed commitment to them before this body, and articulated their grounding in the Constitution.
I'm going to ask Ms. Serrano, you're a former assistant U.S. attorney. You're familiar with these crimes where children are victims. Could you describe the sentencing enhancement around child pornography cases for use of computer, the number of images, pre-pubescent victims, but not so much on the mechanics of it, but explain why we have these enhancements?
It's my understanding that the enhancements were created to recognize the aggravation that the use of a computer or somebody with more images versus less images, or someone with images of very, very young children, they would deserve a higher sentence than somebody who was not had those characteristics with their offense.
Could you explain why possession of child pornography is not a victimless crime?
Yes, sir. So as I said in my testimony, these pictures or videos are real children. They're somebody's kid. They have parents. They have grandparents. They may have siblings. These are real children. And every time somebody views it, downloads it, possesses it, transports it, re-victimizes them. Can you imagine your most embarrassing moments on the internet forever? And this is not just embarrassing. This is brutal, sometimes often very violent, horrible conduct that victims know that somebody is out there looking at it.
Mr. Marshall, based upon your experience, which communities would be hurt most by anti-police movement? And is there anything in Judge Jackson's record specifically that concern you about her jurisprudence?
Appreciate the question. As I raised in my opening statement, what gets lost when we describe the victims of crime is particularly where those victims are located. And those that advocate an anti-police and anti-incarceration statements are advocating directly against those that they claim to be able to speak for. You know, when I hear that Justice Jackson would be a voice for the vulnerable, very rarely do I hear that being described to those victims of violent crime who truly are the innocent and most vulnerable of the system as a whole. My broader objection as it relates to what I have seen of the record is when there is a judicial opinion drafted by the nominee in which she cites the New York Times for a quote that our criminal justice system is unfair and unjust, to me that raises very specific questions about whether the nominee fully embraces whether or not our system is broken or whether or not she believes that the system works. Because to the extent that there continues to be the mindset that our system is unjust, then not only does it undermine the rule of law, but the ability of law enforcement to do their job and the public's confidence in the system in which we all hold dear.
Mr. Russell, mindful of the fact that Judge Jackson told us more than once that critical race theory never entered into her opinions or maybe even a matter of discussion. If a judge or justice is making decisions based upon that theory and those principles, how might we see that reflected in their opinions?
Well, thank you for that question. I think that based on my expertise in religious liberty and constitutional law, I think you always have to start with the original meaning of the Constitution and understand that regardless of the changing of the culture and what the social structure might call for, the standard never changes. And that ensures that there's an anchor and there's constantly a foundation to go back to. And so if you look at the Constitution through the lens of CRT, then you're going to assume that it's inherently flawed and incorrect, and you're less likely to view it as being something or a source that you need to go back to or a source that should be relied upon, and certainly not in the original meaning, because the original meaning is going to be inherently discriminatory if you look at it through that lens. And so if you see it reflected in opinion, say in a religious liberty case, you might be inclined to say change that original meaning in order to reflect the current culture's new understanding of what religious liberty should mean.
Thank you, Mr. Chair.
Thank you, Senator Grassley. Senator Whitehouse.
Thank you, Chairman. Ms. Russell, Ken Klakowski worked for First Liberty before he went to the Department of Justice to become senior counsel to Assistant Attorney General Jeffrey Clark and participate there in the drafting of a proposed letter in an effort to overturn the presidential election in Georgia. Did you personally or did your organization have any role in helping to prepare or facilitate the preparation of that letter proposed by Jeffrey Clark?
No.
Thank you. Mr. Marshall, you were the chairman of the Republican Attorney General's Association and the Rule of Law Defense Fund in the run-up to the January 6th assault on the Capitol. And Rule of Law Defense Fund sent robocalls urging recipients to march to the Capitol on January 6th. Were you personally present in Washington, D.C. on January 6th? Your microphone should probably come on.
I was not.
Did RAGA or RLDF have staff present here?
Can't speak to that, but Senator, what I can tell you is that we have denounced lawlessness. Not only is it related to what took place on January 6th, but also the lawlessness that continues to go on across our country with violent crime. And what I would hope is as part of this hearing, that this body is likewise questioning our nominee about her philosophy on criminal justice as it relates to decisions she would make on the court.
Did you personally know of or approve the text of the robocall that went out from RLDF?
No.
Do you know how that robocall was funded? Was that out of general revenues of RLDF, or was a specific solicitation made to fund it?
No knowledge.
No knowledge? Did you personally solicit funding for that robocall?
Senator, I've made multiple comments here already. The question before this body is the nomination.
I get to
of
ask
Judge
you
Jackson.
questions.
Yes, sir.
And my
what
question
I'm
to
telling
you
you
is,
is
did
that we
you
have denounced
personally
what took place that day, as we do continue to denounce the
for
violence
the
taking place
RLDF
across this country.
robocall that day? Pretty simple question. Yes or no, did you personally solicit money to support the robocall that brought people to the Capitol and who then assaulted the Capitol?
No.
Very well. Did you have any contact with members of Congress in any effort to keep the electoral process open through objections to give those coming to assault the Capitol time to breach the Capitol and disrupt the elections process?
No.
Have you offered any testimony to the January 6th Commission?
Have not been asked.
You've not been asked. As you sit here, you enjoy the protection of the Capitol Police officers who are here and who defended our Capitol against the assault on January 6th by the crowd that your organization helped recruit. Do you have anything to say to them, particularly to those who were injured in the line of duty on that day?
Sir, I object to the premise of your question that somehow or another the organization I was connected with had anything to do with the violence that took place. We've denounced that violence before, and as I've done with you here today.
Is Joseph R. Biden of Delaware the duly elected and lawfully serving President of the United States of America?
He is the President of this country.
Is he the duly elected and lawfully serving President of the United States?
He is the President of our country.
Are you answering that, omitting the language duly elected and lawfully serving purposefully?
I'm answering the question. He is the President of the United States.
And you have no view as to whether he was duly elected or is lawfully serving?
I'm telling you he's the President of the United States.
No further questions.
Senator Cornyn?
To me, one of the most important aspects of the confirmation hearings is the opportunity to revisit first principles about our government, separation of powers, freedom of speech. Ms. McCollum, thank you for your eloquent testimony about the importance of free speech. But I want to, Professor Mascott, I want to start with you and take you back to the Declaration of Independence, where it says that government derives its just powers from consent of the governed. And while we heard a lot from the nominee about staying in her lane, not making policy and the like, I personally believe that many judges have a blind spot when it comes to things like substantive due process or articulating new and unenumerated rights and eliminating any discussion or debate or even vote on some of those rights that they discover because the judiciary says this is the way it is and we don't care what anybody else thinks. Could you just describe for us the danger of eliminating from consent of the governed some of these important decisions under the guise of judicial lawmaking, like substantive due process?
Yes, Senator, thank you for the question. And I think it's great to go back to considering the consent of the governed, obviously, because the right of the people and liberty is foundational to our constitutional system. And as my written testimony goes through in more depth than I mentioned today, I mean, I think there are multiple structural limitations in the constitutional system, some that we often overlook, that lead to quite a modest role for judges. So first, there's the role of federalism of the states, the people, our important institutions like religious bodies, the family, continuing to have a great say, we the people, that limits really the power under the text of the Constitution that the federal government in any branch is supposed to exercise.
The federal government is one of limited powers, correct?
That's correct, Senator, listed in Article 1 of the U.S. Constitution. And so that structural constraint is the first threshold thing to be considering when thinking about the federal role and the where the source of the legal and constitutional authority for law to begin with. And then even within that system, as this body's discussed many times, there's the separation of powers among three branches. And of course, with Congress being closest in elections to the American people and the president being elected, the role of the judiciary is quite modest.
Since our time is limited,
Sure.
Let me ask another question. And when judges get outside their lane, when they make policy, when they make political value judgments, does it violate those principles that you've articulated about our form of government and the limitations on judicial power?
Yes, Senator, which is why it's important to have a muscular reliance on the text and structure of the Constitution and statutes.
Ms. Russell, I know your practice involves protection and defense of religious liberty. That's another provision of the First Amendment that Ms. McCollum addressed, that beyond free speech, the freedom of religion in our country. And when the Supreme Court justices identify new unenumerated rights and hold that no state, no local government can enact any policy in conflict with that new right that they identify, does that potentially endanger the religious liberty of Americans?
Well, yeah, it definitely could if you are not taking into account sort of the, as I said, the foundational importance of religious liberty, and you instead usurp that with the new right that you've created that was likely not considered when the initial provisions of the Constitution were drafted.
And in the Obergefell case, I think Justice Alito and perhaps Justice Thomas and others expressed their concerns that when judges make law and create a national standard and take these issues out of the debate that they ordinarily would be subject to in the political system and in the legislative branch, that basically people who don't agree with it, let's say because of sincerely held religious belief, could be identified as bigots.
Well,
Do you share that concern?
Well, yes, because certainly if you create a new right based on the current prevailing culture and their thoughts about whatever it might be, generally speaking, you're going to end up in a situation where everyone who has a traditional view of those subjects are going to be seen as the enemy, and they will be demonized in the culture.
And it's the ultimate cancel culture.
Ultimately, yes.
Thank you.
Thanks, Senator Cornyn. Senator Klobuchar.
Well, thank you very much, Chair Durbin, and thank you to all of you. Representative Beatty, thank you so much for your leadership and for being here today. You talked about, in your testimony, about how there have been 115 justices, and only she will be the first, Judge Jackson, if confirmed, will be the first Black woman. And she will also be the first public defender. So those are two firsts sitting in the room where it happens, offering a different perspective. Could you give us your perspective? Two things. One, on what that means as someone that knows what it's like to go into an institution that didn't have different perspectives. That would be the House of Representatives. And two, just your view as a Black woman about the hearing yesterday.
Let me start with your last question. And first of all, Senator, thank you for that. As I witnessed yesterday, and certainly want to say to Congressional Black Caucus member Senator Cory Booker, thank you yesterday. It was emotional, it was heartfelt, but it also spoke not only to Black America, but to America, of how valuable this will be, because what we will see when she is confirmed is what America looks like. We are no longer looking at where we were 56, 65 years ago, but yet we're still fighting for the same thing. So I say to little girls, and especially little Black girls, it will be important for them to see that they could do what her best friend said of her when they were 12 and 14 years old. I think it builds hope for America. And we know that all too often as elected officials, and wanting to get more people who are representative of this wonderful America that we live in. And that includes making the change and having the courage as senators to confirm a Black woman, not because she's Black, and this is what I want you to hear loud and clearly, but because she is qualified, more qualified than most we have seen in this room. And that's not just based on my opinion or my thought, but it is based on facts. It is based on when you look through the 600 some opinions, when you look through the 12,000 pages that were sent here on what she did on the United States Sentencing Commission, The 70-some thousand pages that came from the Obama library? When you look at what all the fact-finding checkers have said about her record, I say look to each of us. And this is why it is important to me. There is not a perfect person in this room. Yesterday, a minority senator said he did not agree with everything that his colleagues were saying. So I think you can look at anything or any person and find something that you want to find fault with. But in this case, there are so many things that she has just been impeccable on her reverence for the rule of law, for her impeccable decision-making. She is not perfect, but she is amazing. And that's what I want America to know. And I just want to end with this because I am also chair of the Congressional Black Caucus. And I want you to know, while we are very diverse, our power is our unity. And we embrace and endorse her 100%. Thank you.
Thank you very much. Thank you. Mr. Henderson, you've been a leader on voting rights. Yesterday, Judge Jackson talked about how the right to vote is a fundamental right in our democracy, as other nominees have said in the past. How can the court, in your view, particularly after what happened yesterday with the shadow docket case in Wisconsin, work to reestablish public confidence in voting rights cases? Very quickly.
Thank you for the question. Thank you also for your leadership in trying to protect democracy in your role as chair of the Rules Committee. I think the court has a very important role to play to preserve the right of all Americans to the vote. We now see democracy under attack in unprecedented ways. It certainly began with the January 6th insurrection, but it continues now at the state level in some states that are rolling back protections that guarantee the right to vote. I am hopeful that the court will re-examine the role it has taken with regard to the Voting Rights Act, which it has stripped of its essential powers at the Supreme Court level. And I think a case has been made that there is a need for a new structured Voting Rights Act. And we hope, of course, that the Senate will ultimately come to accept that requirement.
Well, thank you. Mr. Chair, I'm not going to ask another question, but I did want to say to you, Mr. Rosenthal, as someone who's kept my friends since middle school and high school, I especially enjoyed your testimony, and it reminded me of when I asked one of Sonia Sotomayor's friends in a similar panel, who was a friend from middle school or high school, what she was like at that point. Maybe it was elementary school, and he said, judicious. And I thought, so I enjoyed it very much. Thank you to all the witnesses.
Thank you, Senator Klobuchar. We've been told by the Republican staff that the order based on early bird rule on their side is Senators Lee, Tillis, Blackburn, and Cruz. It appears, Senator Tillis, you're next up.
Thank you, Mr. Chair. Thank you all for being here. I listened to your testimony and watched it in my office. Mr. Rosenthal, you're getting married in a couple of weeks?
Yes, Senator.
Good. Also wish that your father returns to good health.
Thank you.
Captain Thomas, thank you for your law enforcement service and your service in Iraqi freedom. Ms. McCollum, I think this is the first time I've asked somebody questions who were actually a plaintiff in a Supreme Court case. It's an honor. Your testimony was unbelievable. Before I leave today, I hope I can get one of your cards. I think it reads
sure.
Hope, Health, and Love.
Hope, health, and love.
So you were at this abortion clinic as a counselor?
Yes.
Sidewalk counselor. Yesterday, I tried to make the distinction because I think some people were approaching that case as a pro-life or pro-choice case, and I was trying to make the point it was about freedom of speech. You agree with that? I think you said that in your testimony.
Sure.
Now, in the amicus brief that was created, I think there were quotes in there. So these weren't words necessarily of those who created the amicus brief, but they were quotes from, I guess, the plaintiffs in the original case that you were mean, in your face, aggressive, and I think that the other quotes said that they even felt like they may be shot by you. Now, I know that was a couple of years ago, but that seems to be not characteristics of your behavior. Would you agree with that?
Oh, absolutely.
Can you were out there,
Yeah.
you were not the only one. Were there others out there as life counselors or?
Sure.
Yeah, were any of them mean, in your face, people that looked likely to shoot somebody?
No, absolutely not.
So tell me a little bit about the bound. I'm sorry, I got to go quick because I'd like
That's
to hear you
okay.
talk. I'd like for you to repeat your opening statement. But tell me about I was trying to get with Judge Jackson yesterday, who incidentally, Congresswoman, I think is eminently qualified. And I find it hard to believe that anybody on my side of the aisle would disagree with that. So this has more to do with the application of philosophy and worldviews that could potentially influence. But I think you should make no mistake that I agree with the ABA that she is highly qualified, and I'm glad to see she got that rating. But I'm trying to get an idea of what it was like on the ground. They were telling you, now one of the reasons you mentioned in your testimony that you may have to raise your voice is you were so far away from these young expectant mothers who may not have ever known that there was a choice of life that would fulfill them, like the mother who sent you the picture of her 3-month-old baby, who's now in her teens. So I could understand if you're several feet away, you may have to raise your voice just to get their attention. Maybe that's what they meant by shouting it in your face. But with the Supreme Court ultimately striking down the underlying Massachusetts law that was used as a basis for the complaint, were there people that were inside the envelope, or maybe I was trying to determine whether there were people that were escorting them in, which are basically expressing their free speech rights to choice. Were they there, or was it just that, so were there people inside the buffer who were able to escort them in, and your argument was that you want to be there to hold their hand, I think you said, never walk the journey alone. Is that an accurate portrayal of the facts on the ground, that you felt like you were not given fair access?
Fair, that's true.
Okay.
Because, yes, you have it there, Senator. And yes, they are inside the buffer zone, and they're talking to the mother-to-be.
That's what I thought. That's why I just wanted to get it right.
Yes.
And I think it's wonderful that you're here because you're either an Oscar-winning actor or actress, or the fact of the matter is that was a wholly unfair assertion of who you were. Just a quick question. I actually had one for Ms. Russell and Ms. Mascott. I'm not going to have time for both. So, Ms. Mascott, you talked about in your opening testimony the application and practice. I was thinking about a case that Senator Cornyn brought up that had to do with the congressional direction. The plain word of the statute said that the removal, the two, are you familiar with this?
Are you talking about Make the Road, New York?
Yeah.
Okay.
And it was my understanding that Judge Jackson used as a basis for the nationwide injunction that it did not comply with the APA, but that seems to be a tactic every once in a while, even though the plain letter of the text seemed like, and I think it's the reason why it was ultimately struck down by the D.C. Circuit. But do you know of any other examples where Ms. Jackson may have applied a similar logic to a case?
Well, in that particular case that you're speaking of, I think it was not failing to rely on a provision that clearly limited the role of the courts and gave the discretion to make the decision to the acting Department of Homeland Security Secretary. I think in other opinions, what seems to be the case is that Judge Jackson is using a blend of sources, perhaps relying on legislative history or looking at intent or purpose more than other justices in the past who have expressed exclusive commitment to textualism, or maybe in applying canons of construction, perhaps moving beyond text sometimes in a way that might be different from other justices in the past, like Justice Scalia and Thomas. So, of course, it's hard to predict based on district court rulings how a judge will rule, but there are these other instances like the one you mentioned, or in the McGahn case where the D.C. Circuit disagreed that suggests maybe—
in the interest of time, because I know we have a vote, I'd be very interested, thank you for that, but I'd be very interested as a follow-up, if you have time over the next week, to just provide me a few specific examples, if you can. You don't have to go to a great level of detail, but I would appreciate it. Mr. Chair, thank you. And Ms. McCollum, do you have one of those cards? I'm going to get it on the way out. Thank you.
Thanks, Senator Tillis. This isn't a coup. Senator Durbin has gone to vote, and as is customary, one of the members of the committee takes his place. And I'm in the chair now, Richard Blumenthal of Connecticut, and very pleased to have my round of questioning while I am taking the chair for Senator Durbin. Let me ask Dean Goluboff, you have an extraordinary career yourself as a trailblazer, the first female dean at the University of Virginia. You had a distinguished clerkship with Justice Breyer, and before that, our good friend Guido Calabrese, one of the most distinguished judges and scholars in the United States at the Yale Law School, where you went as well. A number of us on this panel have talked about the legitimacy crisis that the Supreme Court faces. Maybe the result of self-inflicted wounds, maybe the result of the times in which we live, but Justice Breyer's very thoughtful, deliberate, methodical approach, as was outlined by Judge Jackson as well, seems to be one of the hallmarks of his ability to bring the court together to overcome divides and disagreements, which in my view is very important at this point in the court's history. Would you agree?
I would.
And maybe you could elaborate as to why that is important for this court at this moment in its history.
I think the court's authority, as Professor Mascott has been talking about in the separation of powers, really comes from its deliberative nature. It doesn't have the power of the sword. It doesn't have the power of the purse. What it has is its reality and perception of being a neutral arbiter. And I think Justice Breyer played a critical role in enhancing and facilitating deliberation across all of the justices of the court. And I think everything that we know about Judge Jackson suggests she will do exactly the same thing.
So the lack of trust and credibility is a threat to the court because it doesn't have armies or police forces or, as you say, the power of the purse. What it has is the trust and respect of the American people.
Yes, that's something Justice Breyer talks about frequently in his writing and in his speaking, is the fact that without the trust of the American people, the court simply can't do its job. The rule of law, the justices are committed to the rule of law, and the rule of law exists because the American people follow the rule of law and only do so when they have faith in the court.
Let me ask, and I think that point is very well said, Congresswoman Beatty and Mr. Henderson, we are celebrating here a remarkable achievement. I've said it should have happened long ago. It's a leap into the present in the historic nomination by President Biden of the first black woman to the United States Supreme Court. But as much as we celebrate, as I pointed out yesterday, the decisions of the court in Shelby County and Brnovich that essentially have set us back, and especially in this area of voting rights, John Lewis was a great friend and hero to you and to me on integration, backsliding as well. Maybe I can ask you to reflect on, both of you, because you have such deep and broad experience and expertise in this area, about the ways that the Supreme Court has reversed some of the progress that was made in our own lifetime. Ms. Beatty, Congresswoman Beatty, why don't you go first?
Well, first of all, let me just say thank you for that question, and I am sure that Congressman John Lewis is looking down on us in a hopeful manner, especially as it relates to civil rights and voting rights. I think what we have to look at first, as was said by both of the professors, that the power is not in the policy or the Congress. So I think what this does with this confirmation would be, it would be a hope for the people out there to help us as members of Congress and also as senators, that we have to first do our job. And I think we have an obligation to help those justices by sending them policy, sending them voting rights legislation that they can then do within the rule of the law what the people are looking for. So I think that it starts here. And I think that question is so wonderful as I am sitting here as a member in the majority, with members in the majority and the minority, that the work starts with the House and the Senate. And so if that question would allow me to say that I am willing, because voting rights is the fundamental of everything that we talk about right now, whether it is the freedom of speech, whether it is working with our police, whether it is being the voice for those who are voiceless. Let's start by saying we're going to give not only this justice, but all of the justices something that they can look at and rule on, because we've sent them something that we're united. And I would ask, since I'm here today and with that question, that I ask my colleagues that we start with voting rights legislation, that we look at where we are with nullification. If we look at where we are in that case with preclearance, if we look at history, the voting rights are in with this, and you know this well. The Voting Rights Act has been reauthorized in a bipartisan way 5 times. 4 Republican presidents reauthorized the Voting Rights Act. Wouldn't this be a wonderful time in this America to build a better America if this Senate and this Congress could come together and send our justices something that they could rule on that would be reflective of our democracy?
Thank you. Mr. Henderson?
Senator Blumenthal, thank you so much for the question. Let me say at the outset that I support completely the response of Congresswoman Beatty and believe her answer was full and complete. But let me also say that the right to vote is foundational of all other rights, as Congresswoman Beatty alluded to. And so all the issues that we've discussed this morning, from free speech to the rights of individual victims in cases of police accountability or others, are all tied to the right to vote. The Supreme Court decision, beginning with the Shelby County decision in 2013, with the Abramovich decision of a couple of years ago, and recent interpretations of what the court has done by district court judges, raise serious questions about the fidelity of the court to the role that Congress has been designated to address discrimination under Section 5 of the 14th Amendment. The fact that the court seems to have gone out of its way to find ways of eviscerating the protection of the Voting Rights Act has taken us back literally to the period that existed prior to 1965 when the Voting Rights Act was adopted. Some people consider that criticism to be hyperbolic, but the truth is the facts make clear that what is happening now to voters, particularly voters of color, younger voters, seniors, individuals with disabilities, are in fact violations of that fundamental right to vote. When we deny access to the ballot, therein lies the problem. And so we have petitioned Congress, specifically the Senate, to enact new provisions that would help to protect the right to vote. We are disappointed that earlier this year that effort was not undertaken with the complete bipartisan support of the Senate, but we hope that in the future that will happen. I remind you that 16 members, Republican members of the Senate, who voted for the Voting Rights Act in 2006 in the reauthorization, have so far been silent on this question of whether to move forward on the act. We hope they have a second opportunity to do so.
Thanks, Mr. Henderson. I'm going to call on Senator Blackburn.
Thank you, Mr. Chairman. I appreciate this very much and the opportunity to have you all before us. This has been really quite a week here in the Senate Judiciary Committee. Ms. McCullen, I would like to come to you first. I am so happy that you are with us today, and I appreciated your comments. I'm a mother and a grandmother, and I like how you talked about walking with women as they transition from their pregnancies to that motherhood, and realizing the need to continue to support women after they have those babies, and to support them as they go through this entire process. Likewise, I know that you do some good work to support post-abortive women.
Yes, I do.
Who just they grieve. And acquaintances that I know that have been through that process, there is a grief that is just many times hard to bear.
It's true.
So appreciate your work, and I know you have a card that you give to women.
I do.
Talk to me just a little bit about that, very quickly.
Sure. Well, I have an extra one here too. And when I walking and a young mother comes up to me, as I said earlier, I say, "Good morning. I'm Eleanor. How can I help you?" And I give them the card at the same time. The card has hope, help, and love, and my telephone number. I'm not afraid to give that out. It has my website. And then on the back, a person's a person, no matter how small.
I love that.
So I just give that out. It just shows that I'm trying not to be a stranger. In just a few moments, Senator, I'm building up trust. And at least they have a name and a number, and I'm not just out there for no reason. I have a purpose.
I appreciate that. Let me ask you this. How did it make you feel in Judge Jackson's brief when she referred to pro-life women as hostile, noisy crowd of in-your-face protesters?
Well, as I said, it made me very sad, extremely sad. And that's not the case at all. In fact, if someone is doing those things, harassing or yelling, the sidewalk is not a place for anger. It's not a place for judgment. Anyone that comes to be a sidewalk counselor should be compassionate, not judgmental, and helpful and kind. So we have workshops. I run the workshops. If a new person
let me move on just a minute, but thank you for that work. Ms. Mascott, may I come to you, please?
Yes.
I closed out last night with Judge Jackson, reading back to her some of her opening statement. Now, everyone up here, as I've listened to you all, the ABA, their witnesses that were with us earlier, you talk about preserving our form of government. You talk about preserving equal access, equal justice. And there was a comment in Judge Jackson's opening that I read back to her because she left out something very important. I'm going to read this to you, and I'd like your comment. I've been a judge for nearly a decade now, and I take that responsibility and my duty to be independent very seriously. I decide cases from a neutral posture. I evaluate the facts, and I interpret and apply the law to the facts of the case before me without fear or favor, consistent with my judicial oath. And I told her there was a word missing from that I thought deserved more attention. And that was, it should have been there, that it should be consistent with the Constitution, because that should be where a justice goes first. Is that not correct?
That is correct, Senator, and I think largely because the Constitution, of course, gives the federal government only limited enumerated powers. And so to be able to have a context for interpreting relevant statutory text, one first needs to think about whether Congress, the federal government, is authorized to take the action in the first place, and where the text then falls within the constitutional structure and the judge's role in interpreting it.
And, you know, we had a very difficult time, never got her to nail down her judicial authority, her judicial philosophy. That concerned us. There's another thing I want to ask you about. This is where she talked about CRT in sentencing. This was from a 2015 speech. And I felt like this was really inappropriate. I also try to convince my students that sentencing is just plain interesting on an intellectual level, in part because it melds together myriad types of law. Criminal law, of course, but also administrative law, constitutional law, critical race theory. Is critical race theory a type of law, Ms. Mascott?
Well, Senator Blackburn, I teach a number of courses at Scalia Law School, and none involve critical race theory, so I would not be the best expert on that. As far as sentencing, though, I think, again, in that area as in all, it's important to focus on the text of law, and of course, Congress at the federal level would have the largest role in terms of establishing the range of appropriate sentences for a crime, and so folks applying that, of course, always would be looking to the text of the laws put into place by Congress. Congress has, over the years, given a lot of discretion, but could narrow it if it decided that judges were not applying the rule properly.
Thank you. Thank you. Mr. Chairman, before I want to ask you, some of us have wanted those pre-sentencing memos. Are we going to be able to have access to those memos? I know we sent a letter to you. Where do we stand?
Well,
with
we've
that?
consulted with prosecutors and with victims' rights organizations, and they share my concern. This is very confidential, sensitive information, which is usually only seen by a judge, and to run the risk of bringing it to this committee and jeopardizing or worse, innocent.
Is there no way we can end?
I'd like to finish.
Okay.
Jeopardizing or worse, innocent third parties, our children who have been victimized. I'm sorry, Senator, I'm not going to be party to that. I would not want that on my conscience, that we did this for some political exercise here, which I think is totally unnecessary, and someone was harmed as a result of it. I'm going to resist it every step of the way.
No one wants to harm children.
Then leave the reports concealed. Leave the reports concealed.
And there's, well, what is in the reports that we cannot go into a classified setting?
I want to tell you something. If you are a parent of some child who's been exploited, and you recognize this judge's name as perhaps have presided at the trial, and realize that now the report that has been kept in confidence all these years is now going to be handed over to the United States Senate Judiciary Committee, what would you think as a mother if it were your daughter or your child? I would think this is an act that is reckless. And to do this in the name of some political, well, we're going to pursue this one more step and request information that has never been requested before by the Senate Judiciary Committee, unacceptable. On my watch, I won't be party to it. I do not want this on my conscience, and I hope you don't either.
I want to make certain that we protect children and that we continue to do our best effort to protect children. I also want to make certain that we're going to have judges on the federal bench and justices that are going to protect those rights of children.
Well,
the fact that you all have seen these,
no,
we haven't.
No, you're wrong,
The fact
Senator.
that even
Senator,
Judge
you're wrong.
Jackson referred.
I can't see them. I don't want to see them.
Okay.
And I want to make that clear. So it has not been given to the White House, nor has it been given to any member of the Judiciary Committee that I know, and I am not going to be party to any effort.
Mr. Chairman, nobody,
Mr. Chairman.
there is no one that wants to do anything that is going to
Good.
harm
Join me.
children.
Join me.
We want to make certain that we do our due diligence. And I know you have gotten frustrated with us with asking tough questions, but that is our job.
You may ask a
do
tough
that.
question as long as it is fair,
And
that's all we ask.
every
Chairman, if I
question
might.
we have asked has been fair.
Senator Coons.
Mr. Chairman, could you just clarify for those who may not be familiar with the procedure and practice of prosecution and sentencing, these PSRs, they were not in any case written by Judge Jackson. Is that correct?
That is correct.
And they are not about Judge Jackson in any way.
That is correct.
They are uniformly or nearly uniformly sealed by court action.
Yes.
And involve detailed and thorough interviews of the whole ecosystem around a crime, the victim, the perpetrator, families, and our
described to those interviewed as something that will be confidential and sealed. Thank you.
And let me just say that I cannot imagine that we think we have to explore this area at the risk of innocent third parties and children. I will not be party to it.
Mr. Chairman?
I'm just not going to do it. Senator Booker.
Again, this is new to me, and I'm sorry, I never did criminal law. But I've now asked a lot of prosecutors trying to be fair about this, and some of them served on this committee, to understand. And the kind of confidential information, I thought, well, maybe you could redact it. And people were saying to me, no, you cannot even redact it. There is so much compromising confidential information that none of us would want out there. And Senator, who I have a lot of respect for and have actually thought a lot of her questions during this were thoughtful and probing and helped me, frankly. But she's new on the committee, but I know this. I've also asked this question. This is a body, this Judiciary Committee, that has, for Republican and Democratic presidents, done, am I fair to say, thousands of judges have been put onto federal benches. And this is a new territory. We have never asked for this kind of confidential information from a third branch of government. It's just never been done. And when you cross a precedent like this, now I've seen this having been 8 years in the Senate, what you're going to create now, first of all, this information should never be released to politicians, in my opinion. There's nothing additive to it. But what you do when you cross that line is now you're going to create a new precedent. So some performative Democrat, when there's a Republican judge coming before us, is going to demand the same information and use it or exploit it for political purposes. I don't think we want to cross that line in this body where this has never come up in the 200 years. I don't know how long this information has been collected in this manner. It just seems like a really large step that I don't think, as you said yesterday, is going to change the conclusions that have already been drawn by people on either side of the aisle. If there's somebody who just wants to come forward and say, I'm on the fence on how I'm going to vote, this is the determinative thing, I just don't hear that. And the danger weighing these, the danger is really, in terms of changing the way this committee operates, impeding upon issues of privacy, I think the danger way outweighs any probative value.
I can't imagine for a moment a parent who has been somehow related to a child exploited in this circumstance, who lives in fear every day of what's going to be made public, what's going to show up on the internet, would view this as just a routine request for information. It is so much more than that. And as I said, on my watch, somebody can take this chair and this gavel over and make a different decision. I'm not going to be party to it. I will not be party to exposing this information to the possibility of disclosure and the harm that can come from it. Senator Coons.
Thank you, Chairman Durbin. Dean Goluboff, thank you for your testimony today. Like Judge Jackson, you also clerked for Justice Breyer, and you're a well-respected dean of a prominent law school. I just wanted to ask a few quick questions of you and a number of other witnesses, if I might. Judge Jackson's jurisprudence has been questioned or challenged, in particular with reference to her opinion in Make the Road New York. Is it your view that she, either in that case or in other cases you may have considered or reviewed, has overstepped the role of the court and has engaged in a jurisprudence that gets outside her lane as a judge?
Thank you for the question, Senator. It is absolutely my view that she does not get outside her lane. She, I think, comes down in cases on both sides, depending on what she sees in the facts and how she applies precedents. I think she has been assiduous and conscientious, both in that case and in others, to think about precisely the kinds of questions that Professor Mascott mentions. What is the role of the court? How much deference to offer to the other branches? How to ensure procedural consistency? She is, I think, quite consistent and very committed to the text and to precedent.
And given your experience with Justice Breyer, what do you think anyone who's clerked for the justice might have learned about an even-handed and impartial manner and consensus building on the court?
Well, I certainly learned, and I think anyone who clerked for him also learned that exactly what you described is crucial to being a good justice, to taking every case on its own terms, to asking what the Constitution says about the particular case at hand, which includes the original public meaning, which Judge Jackson has said, but does not end with the original public meaning. Originalism is really a capacious term, and even among originalists, there are a lot of disagreements about about how cases should come out. Justice Scalia and Justice Thomas disagree quite considerably about how much to consider precedent or not in their own decisions. And the interpretive part of constitutional interpretation is really the first part. You look to original public meaning. That's what Judge Jackson has said she would do. And then the second part is you apply it. And you have to consider the facts of the case and precedent when you do that. And I think Justice Breyer taught all of us that the best way to do that is in conversation with justices across the court and taking the deliberative process very seriously, which he did, creating real relationships across justices so that you can have real conversations and learn from each other as you wrestle with these really hard questions. I don't think we would spend quite so much time thinking about the judge's approach or qualifications if the interpretive process were just automatic and mechanical. It requires judgment, it requires discernment, and that's what Justice Breyer taught us.
To follow up on a previous exchange, do you have any doubt that Joseph Robinette Biden Jr. is the duly elected president of the United States?
I do not.
Thank you. Captain, if I might, Captain Thomas, I was a county executive of a county, had the second largest police force in my admittedly small state. We had a very active chapter of Noble. I have a long working relationship with some Noble leadership, and I'm thrilled that you're here as the head of Noble, our nation's largest law enforcement organization of black law enforcement officers, which has also endorsed Judge Jackson's nomination. How do you view her record, her commitment to public safety, her engagement with the law enforcement community?
Well, thank you, Senator. With all the information that we have received, different notes from different organizations, I feel very confident in her nomination for this seat. I'd like to make a statement. Her temperament, her fairness, her respect for the law, and her honor of the Constitution make Judge Ketanji Brown Jackson exactly what we should expect from someone who will rule on matters that will affect our country and judicial system for generations.
Thank you.
Thank you, sir.
Thank you very much, Captain, and thank you for the clarity and forcefulness of that endorsement. Congresswoman, I might just ask you a closing question. I've been struck at Judge Jackson's personal story and at the central role that the doors of opportunity opened by HBCUs to her parents has played in that impressive arc of her story. I'd just be interested in your sharing with us the role that HBCUs play in our education system, in our nation, and in providing that remarkable pathway forward.
Thank you for that question. And as an HBCU graduate, as well as all 5 of my siblings, I can speak to that directly. I had an opportunity to probably attend any university that I wanted to, first generation going to college. But thank goodness for my parents who said to me that I would be more balanced and more grounded as a young girl coming from public school system in an inner city school, that they thought it was important for me to do that and then later go wherever I wanted to. I think it gives you that extra sense of confidence. I think it also made me value that diversity. I had people from the continent of Africa teaching me. It was the first time in my history that I had seen so many professors and scholars who looked like me. So it made me soar when I walked into other rooms. I think like Judge Jackson, when I heard her tell her story of how she felt that first week or month at Harvard, but it was, I believe, her success and confidence and wind beneath her wing, her parents. Her parents and that grounding of HBCU universities, and that's what they do for so many of us.
Thank you.
So I think it plays a valuable role.
Thank you, Congressman. Thank you, Chair.
Thank you, Senator Coons. Senator Cruz.
Thank you, Mr. Chairman. Just a moment ago, Senator Coons was having an exchange where he described Judge Jackson's jurisprudence as assiduously fair and even-handed. Professor Mascott, in Make the Road New York versus McAleenan, Judge Jackson found a cause of action to challenge the Department of Homeland Security's determination of the scope of which aliens are subject to expedited removal. In doing so, she disregarded the plain language of the statute that explicitly said the Secretary had, quote, sole and unreviewable discretion to set the designation at any time. That decision resulted in a nationwide injunction preventing the Department of Homeland Security from removing illegal aliens from this country. That decision was reversed by the D.C. Circuit unanimously. In your judgment, was her decision in Make the Road New York versus McAleenan assiduously fair and even-handed?
Well, Senator, I cannot sit in judge motivation of what was driving particular interpretation. In terms of the interpretation of the statutory text and structure, the opinion overlooked the clear discretion that was given to the Acting Secretary of Homeland Security in the expedited removal context.
Plain and explicit text of the statute.
The plain and explicit text of the statute, and actually text of the statute that had been applied several times previously when acting heads of the Department of Homeland Security had, using just policy notice, made changes in expedited removal.
Thank you. Let me shift. Ms. Serrano, thank you for the work you do with children who are victims of sexual exploitation. The work you do is very, very powerful. As you know, significant concern has been raised by myself and others about Judge Jackson's pattern in sentencing criminal defendants guilty of either possession or distribution of child pornography. In the Harvard Law Review, she wrote a note advocating a new way of examining restrictions on sexual offenders and arguing for a standard that, if applied, would likely result in striking down the sexually violent predator civil commitment laws in states across the country, and could arguably also strike down the sex offender registry laws across the country. Ms. Serrano, what would be the effect if the view she articulated in the Harvard Law Review was adopted by the Supreme Court, and if those laws in turn were struck down?
I'm not familiar with Judge Jackson's writing in the Harvard Law Review, but I can tell you that sex offender registry plays a critical part in allowing the community to identify where people who have demonstrated by their conviction of a sexual interest in children or other exploitative behavior such as rape or that sort of thing. As far as civil commitment, there are certainly state laws. I'm not familiar with all of them, but there is a process in which the due process is done, whether someone should be civilly committed because they cannot function in society due to their sexual deviance.
So, Ms. Serrano, we've gone over in some detail. The Democrat talking point is that criticism about this issue is based on cherry picking. Yesterday, I gave Judge Jackson a chance to explain all of the child porn cases she's ever sentenced in. And that's a universe of 10 cases. Of them, 5 of them, Downs, Cooper, Hess, Kane, and Buttrey, 5 of them, she sentenced the statutory mandatory minimum, the absolute lowest sentence that was allowable under law. She has a pattern when there are prosecutorial recommendations of sentencing on average 48% less than the prosecutors have asked with regard to those in possession of child porn. And she repeatedly articulates, for example, in the Cooper case, but she does this in every case, she articulates that she thinks the sentencing enhancement for the number of images of child porn makes no sense and isn't valid. And rather than having a 5-level sentencing enhancement, she reduces it to a 2-level enhancement. Ms. Serrano, does that make any sense to you that there is no difference whatsoever between a defendant who is in possession of a single image versus another defendant who is in a possession of hundreds, or in one of the cases in front of Judge Jackson, someone that had 6,700 images of children, some very, very young children, infants, toddlers? Does it make any sense that she would systematically say those are identical and that she's not going to apply the enhancement in the guidelines?
Thank you, Senator. I am not familiar with Judge Jackson's sentencing. I apologize. I was doing my day job yesterday, so I wasn't able to watch the hearings as much as I would have liked to. But I can share with you that the increases for the number of images, I think, accurately reflects the type of offender that you're dealing with. Somebody with you mentioned 6,700. That's actually on the low side. When I was doing prosecuting cases, we're talking about people with terabytes or millions of images. And so somebody with that type of collection should conceivably be sentenced more harshly than somebody with, say, 20 images or 50 images.
Thank you.
Thank you.
Thank you, Senator Cruz. Senator Booker.
Thank you very much, Mr. Chairman. I actually really love this. I've been through 3 Supreme Court justice hearings, and when the 10 people come forward from all different backgrounds in America, and people supporting a candidate and not supporting a candidate, it is always uplifting to me. And I have a lot of respect and honor for everybody on this panel. You all are great Americans who are dedicated to this country's highest ideals as you see them. And to give you an example of why I'm so serious, I had in a previous panel of a Supreme Court justice I was dead set against, my constitutional law professor come in and be dead set for them. And I love this professor, still do, and I love him not just because he was a great professor, but also because he passed me. But I just want you to know, you may feel partisan tension in this room, but there is a lot of respect for the 10 of you who took time out of your schedule. Many of you traveled a very long way, and so I want to say thank you. Mr. President, Captain, my questions are for you, but if you don't mind, I'm going to take a quick minute to address the Congresswoman and just want to say a couple things to her publicly that are really important. First of all, the Congressional Black Caucus, it has been one of the greatest privileges of my life to be a member of too few senators that have ever been a member of that body. And I want to say publicly, because this is true, I tried for years to get on this committee, and the Congressional Black Caucus advocated for me for years. Went to Chuck Schumer and said, you need to get Senator Booker, not just because you haven't had an African-American on there for a long time, but you guys saw faith in me that I could represent well here, and I just want to thank you for that. And the second thing is just very personally to you. I had one of the most difficult summers of my life last summer. You know this, my brother had a terrible stroke. And when you see people up here on this panel, you don't know what they all have been through. I did not know that the chairwoman of the Congressional Black Caucus had a horrific stroke at the age of 50 that left her seriously debilitated to the point where you could not walk. And your story at my time of family crisis to me, talk about tears. You were one of the best people I spoke to by telling me your story. And I see you now sitting there. It just is tremendous to me who you are, and my depth of love and respect for you, especially showing up for me at a time I really needed it.
Thank you.
Really quickly, sir, I love Noble. They were on my transition team to be mayor of the city of Newark. I learned from your organization, your recommendations to me about a city that was really struggling with crime. And I'm happy to see Honorable Marshall and others who have to live this life of knowing, confronting some of the ugliest parts of our country, which is what happens in communities that are struggling with high rates of crime. I want to say for the record, because it often doesn't get said, Chris Murphy's book put this data point in there that there is much gun violence in inner city communities as there are in other low-income communities that might be rural and might not have the same ethnic diversity. So I don't want to pick on any communities here who are struggling with crime. Red states have high crime rates, blue states have crime rates. This is not a partisan issue. This is a human urgency. I have shown up before ambulances at sites where young people have been shot. I've seen the horror and have been traumatized. And I have so much respect for police officers because what they go through every single day on the brink, often in the gap between safety and not safety. I have seen my officers. I remember a shooting where my officers ran in, no situational awareness, upstairs to see a woman who had committed suicide and had shot her baby. Mm-hmm. And then they go back to work the next day. And so I just want to ask you, then I'm done, this one question, because I know what's at stake. And here is a Supreme Court justice to the highest court in the land. And there have been people casting aspersions that she may not be the justice that would keep us safe. As a person in this room, I doubt there's anybody more in this room right now that lives in that gap between safety and horrific violence. Why are you so confident, despite all the aspersions that have been cast, that this person will be a phenomenal justice for the safety and security of families in America?
say they're going to start with the law enforcement that we have present throughout the United States now. The Supreme Court justice just going to make it more, if it's something get before the Supreme Court dealing with law enforcement, it can make a difference, but we got to start at local level with the law enforcement. So that's why my organization, NOBA, is so important. We out there discussing things with high crime, gun violence, but we have a significant program, the law in your community. And it starts by a conversation to stop a confrontation. So everybody get involved, get the chapter. We've got 50 chapters throughout the nation. We all try to get on the same page. The crime, they're going to continue, but we can make it better. We're trying to build trust back in the communities with law enforcement. That's our main purpose. Judge Ketanji Jackson, she knows about some of the neighborhoods. She grew up in Miami. Miami have a high crime rate. She said she saw it firsthand growing up. She saw it firsthand. So the decision when it comes to law enforcement is going to be important because we all got to live here in America. But we can start making a difference today by that nomination, and not just pass a nomination. We talk about the voting rights. We talk about everything in this. I'm saying I've been watching this confirmation hearing, man, since Monday. I'm like, man, I don't believe this. Because I've never been to this, though. It's a big history class, you know, and civics class, I remember civics. But she can make a difference. Not only her, but she got 8 other associates on that Supreme Court team with her. They all gonna have to sit down and talk and make this better together. One person not gonna solve this problem. One person not gonna make a difference. But she got 8 other justices on that Supreme Court. And everything's going fine, people. America's doing a great job. I don't get caught up into the politics, the Democrats, the Republicans. I'm just being honest, I don't. But I know it's needed, and I know we got to get things done, so everybody got to work together. Everybody got to work together. But we do need Noble out there in the communities nationwide, so you need one in your city, contact Noble.
Amen. Everybody has to work together, Chairman.
Right.
Thank you.
Thank you, Senator Buchter and Captain Thomas. The next up is Senator Hawley.
Thank you, Mr. Chairman. Thanks to all the witnesses for being here. Ms. Serrano, if I could just start with you, I want to say a particular thank you to you for the work and the incredible work that you do when it comes to human trafficking, child trafficking in particular. I know that you were 18 years as a federal prosecutor handling child pornography and child exploitation offenses. Those are terrible crimes to have to prosecute. And I want to thank you for doing that, and thank you now for the work that you do with Operation Underground Railroad. I mean, it's just incredible. I wonder if you could speak to us a little bit from your experience as a prosecutor and now as someone who is working to combat this epidemic of human trafficking, child sex trafficking in this country. It's a global epidemic, actually, but it's one, unfortunately, in this country, too. Can you talk to us a little bit about what you have seen in your experience about the connection between human trafficking and child pornography?
So human trafficking is a broad term that covers a bunch of different types of crimes, whether it's forced labor, et cetera. But within that, there's the sex trafficking. And oftentimes when you're dealing with sex trafficking of minors, part of the process to break down the victim or potentially advertise the victim to sex buyers, traffickers, or folks create child pornography, which are sexually explicit pictures of children under the age of 18. Likewise, the flip side is if someone as a young child has been sexually abused as a child, perhaps they were victims of CSAM, child sexual exploitation material, they may not have gotten the resources or aftercare, for example, that my organization provides to get them the help that they need. And unfortunately, they become very vulnerable to become trafficked. So it's kind of like a chicken and the egg problem where sometimes one will influence or increase the other.
So let me ask you this. In terms of the children who are exploited in these images, is it fair to say that many of these children were sex trafficked, that they are trafficking victims themselves?
Of the ones that we can identify, sometimes, yes. The children that are depicted in the child pornography or CSAM images, some of them are trafficked, yes.
And what about the demand side of this? because unfortunately the reason that there is human trafficking of any kind, including sex trafficking in children, is because there's a demand for it. And in your experience, does child pornography help drive the demand for human trafficking and sex trafficking of children?
It can, yes. An argument that I would routinely make before district judges in my district would be, sometimes you have individuals who are looking at images online of child pornography. And then oftentimes that will not satiate their need for this material, and they'll go out and actually commit an offense. It's no different than you walk by, and this is a very simplistic analogy. You can walk by a bakery and smell the sugary, chocolate cake, but sometimes it gets to you so much you go in and buy a slice. Again, it's very simplistic. I'm not trying to make light of it, but that's a very simple analogy to explain it.
Yeah, thank you. Thank you for that. And again, thank you for the incredible work that you do. Mr. Marshall, General Marshall, thank you for being here. You're a prosecutor. You have been, even before this role, which is a prosecutorial one, you were a district attorney. Let me just ask you, when you recommended sentences to judges, which you would do in your role as a prosecutor, did you base your recommendation on what you thought was necessary to keep the public safe?
Senator, absolutely, and also the egregious nature of the facts that we were dealing with.
So if you made a recommendation to a judge and that judge went 90% or more below your recommendation that you thought was necessary to keep the public safe, would you be worried about the effect that might have in terms of endangering members of the community?
Gravely concerned, not only as it related to the particular case, but also the message it sent to the community about how we would hold individuals personally accountable for crimes they commit.
So in other words, if you have a judge who consistently sentences, let's say in an area, let's say child pornography, below what the government is asking for, what guidelines are asking for, you're saying that the message that sends is that you're not very tough on this, you're not willing to hold these people accountable. Have I got that right?
Absolutely.
So let me ask you this. You said also, you sentence based on the gravity of the crime. When it comes to things like child exploitation and images that exploit children, would you say that if you have an offender who has thousands of images, that's probably worse than an offender who has one or two, and that you might want to sentence that offender with hundreds and thousands more than the person who has one or two? Is that a fair thing to say?
It's fair, and in fact, it's been my practice. As somebody that has tried and convicted those who traffic in child pornography, I've had a chance to be able to see those images, because one of the things that I also do as that advocate is for that child that is in that image that has been harmed as a result of what's taken place. And so not only do we want to be able to deter that conduct, but also we want to be able to be that voice for the voiceless in this case, and those children whose images are being trafficked.
Because they often, the kids who have been trafficked, their images have been used, they often don't have anybody to speak for them, right? You come into court, the judge has got to do justice. In a way, the judge has got to do justice by them, on behalf of them, because there's nobody to speak for them. And it's not like they don't get to prosecute the case, right? A lot of times we don't even know who these kids are. We can't find them. We can't help them. So it's really up to the court to do something on their behalf. Is that fair to say?
The court is the ultimate voice.
Yeah. I wish that Judge Jackson shared your perspective, General. Thank you.
Thank you, Senator. I want to apologize to Senator Serrano. I recognize Senator Booker, and she was next in line. I hope she will forgive me.
I forgive you.
Thank you. Now I recognize.
Well, if you're asking for forgiveness, I was supposed to read something into the record just to ask Senator Serrano. The NAACP Legal Defense Fund asks that we enter their report into the record. May I do that?
Go ahead.
I would like to ask for that to be entered into the record.
Without objection.
Thank you very much.
Not patient. Thank you very much, Mr. Chairman. Captain Thomas, Noble's support for Judge Jackson is a powerful counter to the foundless charge that Judge Jackson is soft on crime. I thank all of you for being here. Congresswoman Beatty, we all know that Judge Jackson is eminently qualified. Her character, her integrity, her humanity, her kindness, her fairness, her leadership, these were qualities that were apparent from a really young age. And I thank Mr. Rosenthal for telling us about what she was as a young girl. It's an incredible story, and I really enjoyed listening to you. Congresswoman Beatty, as you listened to Judge Jackson yesterday, especially when she talked about her experience at Harvard and the need for perseverance, I was going to ask you whether you could relate to that, but clearly you could, and so could I. Do you think the message of perseverance is a powerful message, especially to Black women and girls in this country?
First of all, let me just say not only thank you for the question, but thank you for your service and what you represent. I think it is an extremely powerful and needed message that we send out to little girls, all little girls, but specifically those who are of color. And I think what you saw yesterday builds for our children, grandchildren, and those yet unborn, because even today, we are fighting for things that we were fighting for in 1963, 64, 65, and 68. So today could not only be landmark as we do this, it could propel us for the future that every little girl will then believe that she can soar.
And believe me, as an immigrant, poor kid, I can relate. It was a very touching moment yesterday.
Let me just quickly say this, because we talk about the rule of law. I think you also have to look at judicial temperament. And what you saw yesterday, beyond her talking about her early childhood, was her response to the tough questions, maybe I think some unfair questions. You saw judicial temperament.
Exactly. Thank you. Dean Goldboff, we know that many of the Supreme Court decisions are unanimous or pretty close to that, but then we're seeing more and more 5-4 or 6-3 decisions. And as I said, we have a very, in my view, an ideologically divided court. And you were asked earlier what the impact of these kinds of split decisions, especially in areas of voting rights, LGBTQ plus rights, abortion rights, workers' rights, union rights. These are the most consequential kind of cases where we can expect more split decisions. Judge Jackson was asked repeatedly about her judicial philosophy, and she does have one. It has to do with her methodology. I wanted to ask you, do you think all of our justices should view themselves as originalists?
I think every justice has to read the Constitution as they think they should. I think they have to be committed to the Constitution and committed to the judicial role in the constitutional scheme. But I do not personally think that everyone has to have the same approach to the Constitution.
I agree with you, because as an example of an originalist, if we were to follow Justice Scalia's view of originalism, we would not have same-sex marriage in our country, because the Obergefell case would have been decided very differently under Justice Scalia's view of originalism. And in fact, Justices Thomas and Alito, also originalists, and in their view, they've already signaled that they would like to revisit Obergefell. I think the LGBTQ plus community is very, very concerned about that. For Mr. Henderson, excuse me, thank you very much also for being here. You represent an organization deeply committed to protecting the rights and civil liberties of all Americans. What would you tell Americans who want to know if a future Justice Jackson will stand up for them and protect their rights?
Thank you for the thank you for the question, Senator. Let me say, I begin first with Judge Jackson's preparation for the role that she hopefully is about to assume. And you've heard both in the days that she testified and again today how exemplary her credentials are, how she has prepared herself in a way that was really destined for this moment. She has the embodiment of fairness and judicial temperament. She brings a level of excellence and preparation unparalleled in the appointment of Supreme Court justices. There is a deep sense of commitment to fairness that she exudes, both in her writings as a judge, but also in her daily interactions, both on and off the court. There is a fundamental sense of inherent fairness that she certainly embodies. And I think all Americans and persons who are not American citizens but are in this country are guaranteed that she will approach the Constitution with fairness and will approach the individual circumstances of the cases before her. I think that's all we could possibly ask a justice to do.
Thank you. Thank you, Mr. Chairman.
Senator Padilla.
Thank you, Mr. Chair. You know, over the last 3 days, we've heard over and over again, as we should, about the incredible qualifications that Judge Ketanji Brown Jackson has to serve on the Supreme Court. And I know I've touted them each and every day of this hearing myself. Hopefully you've seen me do it if you've been watching the hearings, and I'm going to do it again here in a minute. But before I do, I want to explain why I'm doing it, why I keep doing it. It's because I do believe every American should know Ketanji Brown Jackson, the judge, Ketanji Brown Jackson, the person, and the fact that she represents the very best of our country. That she's not just qualified, but extraordinarily qualified to serve on the Supreme Court of the United States. And because of her qualifications and with her experiences, professional and life experiences that she brings, she will make the Supreme Court better. And she will make our country better. So it is my sincere desire that for anybody watching these proceedings, from the audience here in this room or from home or online, if you take nothing else away from these last 4 days, it's Judge Jackson's qualifications. A public school education, followed by degrees from Harvard College and Harvard Law School. Clerkships at the Federal District Court, at the Federal Court of Appeals, and the United States Supreme Court. 2 years as a federal public defender. 2 years as a staff member of the United States Sentencing Commission, and 4 years as its vice chair. 3 separate confirmations by the United States Senate, each time on a bipartisan basis, including 2 lifetime judicial appointments. Nearly a decade of judicial experience, which is more than the combined total of 4 of the currently sitting justices at the time that they were nominated. And of course, the life experience as a Black woman, as a working mom, and so much more. But it's not just her resume and background that makes Judge Jackson so qualified to serve on the Supreme Court. We've all seen over the last 3 days, how she answered every question and met every unfounded, unfair, and insulting accusation with a level of grace, dignity, and patience that very, very few of us would be able to demonstrate under similar circumstances. And she demonstrated that she's sharp and thoughtful in her responses to legal questions. And she clearly has an understanding of and a commitment to the rule of law and the principle of equal justice. Now, based on her background, her experiences, and her qualifications, in my view, Judge Jackson merits strong bipartisan support from this committee and from the Senate as a whole. My question is this, and I address it to Congresswoman Beatty and to Mr. Henderson. For those who are concerned about the politicization of the Supreme Court towards one end of the spectrum or the other, what would it say to the country if even someone with Judge Jackson's background, experiences, and qualifications cannot earn bipartisan support from the Senate?
Thank you so much, Senator. I think it would be a sad day in America. As my friend and colleague Wayne Henderson said earlier, when we look at this confirmation and we look at voting rights and when we look at all the things that you are debating today, it is the fundamental grounding of our society and our communities. So I think today, how can you say on both sides of the aisle, as Senator Tillis looked at me and said, he and his colleagues agree that she is exceptionally qualified. Then we have heard about the cases that have been brought before us that have been in question by some of my colleagues on the other side. 10 cases, but it was 5, but they were still within the rule of the law that she was given to deal with. So if you look at all the charts that we've seen, with all the boxes to be checked, more than any other justice that some of the same people here have voted for and confirmed when questions about cases in the same vein have appeared, she still is above all of them. So the answer to that question is, how can we not? And as a Black woman who's lived through civil rights and everything else, let's send the right message. Thank you.
Thank you. Mr. Henderson.
Senator Padilla, your question is so powerful, particularly after you restated, as you did so eloquently, all of the factors that have brought Judge Jackson to this moment. Her background is absolutely extraordinary, and her demonstration and mastery of the law is second to none. If someone, an American citizen, who has overcome the challenges in one's life that she has overcome, demonstrated her ability beyond any reasonable doubt, and is unable to get the bipartisan support of members of this committee, indeed, it is a sad day for this country. The signal that it sends to the American people is that at the end of the day, preparation may not be the standard by which you are measured, and instead something else, intangible perhaps, in this process comes through. That's not what we want for America. That's not what we in the civil rights movement have struggled for our professional lives to help bring to this country. It would be a sad day. My hope is that the partisan considerations that may have affected some in the questioning of Judge Jackson will be set aside, and that members of this committee, out of their love for the country and its people and the future of the court, will do what's right and will make Judge Jackson a unanimously confirmed appointment. Now, I'm dreaming. That's not going to happen. But certainly, I think sending a signal to the country that indeed we recognize the qualifications that she brings to the table and we lift them up in the name of the American people is something that I hope we can all do. Thank you.
Thank you, Senator Padilla, and thank you to the panel. And I welcome all of you to this room, and thank you for your contribution to this historic occasion. I said at the outset, and I want to repeat now, my gratitude to my ranking Republican member, Senator Grassley, a true gentleman and friend who believes, as I do, that this is one of the most important assignments in a Senate career, to be on the Judiciary Committee at this moment in history. I believe that the admonition of the leader on the Republican side, Senator McConnell, that our hearing be fair and respectful of the nominee was largely upheld by the members of the committee, and I hope that we can continue in that vein. But before we close today, I want to mention those who have helped enable this hearing to run so smoothly. Gratitude starts with the officers of the United States Capitol Police. These officers keep members and staff safe every single day. But this week, we've asked them to take on a greater task. Keep us safe, keep our buildings secure, and ensure that the guests in attendance play by the rules. I can't thank them enough for all the hours they put in toward that mission. I also want to thank the staff from the architect of the Capitol, Senate Sergeant at Arms, Senate Recording and Press Galleries, and others who worked so hard to set up this room and give access to the public and press and to keep this hearing running. Finally, a special thanks to the committee staff, designated and otherwise, who have worked tirelessly on behalf of members and staff on both sides of the aisle. I'll have more thanks to offer in the weeks ahead, but again, my deepest gratitude to all who've made this hearing a success. Please note the record will remain open until 5 p.m. next Thursday for the submission of letters, statements for the record, and similar materials. And with that, the Senate Judiciary Committee stands adjourned.
I was thinking of a different one. Oh.